in the classroom appreciate and respect what is going on. Thank you, Mr. Chair.
Catherine Delahunty.
Yeah, just on that point, because I think it's really critical. Maybe some of these people are raising issues around whether you may not leave versus you cannot leave, or the child. I'm actually strongly of the view that some of our students, especially those with learning support needs, take things very literally. So I actually could accept the SOP the way it's written myself. I think that it's okay, but I am also aware that other people don't, and so I'm interested in whether there is any room to kind of look at cannot versus may not, because we don't want our kids to think they cannot physically leave a room. That's the whole point of getting rid of seclusion. But I guess what the teachers are saying to us is sometimes we want the authority to say you may not leave this room. But I hear the Minister on the issue of this has been talked through in terms of the legal implications, and I just hope that it doesn't end up with being a legal battle over the words may not, which aren't in the Act, in the clause, and cannot, which are there at the moment. But I'm taking a child rights approach. Just on the issue of seclusion, I have a supplementary order paper that just goes a little bit further, because I'm very passionate about this, which is in rightly removing the issue of seclusion and the opportunity to use seclusion. And we found out that a larger number of schools than we realise were doing it, which is different from timeout. I have a supplementary order paper which talks about providing some alternatives in the law. So I know there's guidelines and there's been discussion, but families came to the SET committee and said, if you take away the seclusion, which we really want you to do, please give us something in the law so we can go back when things go wrong, or we can encourage schools. And so my alternatives is that we should have nationally funded and compulsory professional development which equips schools and boards of trustees with the ability to identify and implement alternatives to the seclusion of a student or child as defined in the Act, and supporting schools and boards of trustees to understand fully inclusive practice as a human rights issue for every child, because we know that there's huge diversity in the school's understanding of inclusion at the moment. We know that there's great professional development, but it's opt-in, so it's not compulsory. We know that in initial teacher education, some young teachers have had less than 3 hours in a 3-year degree on what inclusion is. We take away something that is very wrong and that we really need to get rid of, and I'm all for it, but we really need to make sure that the schools legally know what to do next. And I know the guidelines will help, but I really think that unless we actually commit to how serious we must really seriously commit to this professional development process. And that's boards of trustees as well as schools. And it's about understanding fully. If you understand the fully inclusive practice of inclusion, then you have an alternative to seclusion. But right now, I think we're taking away something that that should never have happened. But I'm not sure that schools, and I've seen some of this in the media, are very clear about what to do. And so sending them a guideline will only work as well as their understanding of that guideline. And if there is no compulsory professional development to understand what inclusion is from a human rights perspective, because that school has not made it a priority, has not sent their teachers to the Tips for Autism course, or has not had that professional development and has not seen it as a priority, it's for those schools that I put up this SOP, so that actually we cover off everything. Because I'm all for this. Let's get rid of this abhorrent approach, but let's make sure that there's an alternative strategy so that schools don't feel that they've got nowhere to go. So I would be interested in whether we need to do anything about the may not, cannot stuff. I'm also interested in the Minister's views on my SOP, because alternative support is absolutely critical. Thank you.
Tracy Martin.
Kia ora. Thank you, Mr. Chair. Thank you very much to the Minister for the contribution there. I agree with my colleagues, and New Zealand First will be supporting SOP 308 by Catherine Delahunty. We'll be doing so because this must end, but it can't end without that gap being filled. And what is happening is the pressure with regard to professional development at the moment. The School Trustees Association certainly has been given funding to better invest in upskilling our boards of trustees. This particular issue has not been an issue high on the agenda of that training at this time. but also the professional development for staff, if not funded by the Secretary, and we have had it in numeracy and we have had it in national standards and so on and so forth, funded from a central fund, then this will have to come out of the operations grant. And that's just another stretch on the operations grant. So New Zealand First will definitely be supporting Supplementary Order Paper 308 because it must end. But if I understood the Minister correctly, and I absolutely believe, if I'm right, what we're saying is that a teacher can place a student inside a timeout zone and make a statement like, when you've calmed down, you can come and see Mrs. Kelly at reception. Now that's a different way of saying you may not leave this room. Do you see what I mean? And that's the sort of professional development. I know it might seem minor, but it may not occur to a person in the instance of aggression or the high tense, and when a teacher's got 30 other students over there and trying to deal with this. So if we can give guidance to teachers and give professional development around this concept to teachers, then we need to do so rather than just removing what has been a terrible practice to date. Also, the boards of trustees, this would come under their discipline policies. This is part of the area where boards of trustees needs to be upskilled around their own policy around discipline, because the seclusion laws that are here now should be included inside the discipline policy so that they make it clear that it is not available. But they outline clearly how time out as opposed to a Kiwi suspension. Because now what we've got is we've got those two things working parallel. We all know that a Kiwi suspension is not appropriate, because, and it's outlined in the Youth Law Discipline Procedures booklet, but we're talking time out. How do boards of trustees, particularly new boards of trustees, understand that to be the case? How are they going to recognise the difference, and how will they realise their responsibility about professionally developing their staff? So we support that SOP. I'm now going to come back to SOP 298, which is an SOP in my name that removes the capacity of the minister to appoint a trustee as a presiding trustee. So I come back to the question that I was asking previously wrongly in the last theme. So New Zealand First has no argument whatsoever about the ability of the minister to appoint a trustee onto the Board of Trustees as an early intervention model. We understand that, absolutely get it. But why, as the chair? As I mentioned before, the chair, and I've been the chair for many, many years of Maharangi College, as the chair, I had no greater status than any other member of the board. I only had one vote. It was my job to make sure that the roles and responsibility of the board were met. I certainly had to sign off on all the documentation that had to be filed with the government, with the Ministry of Education. But there were two things that were my role more than anybody else's role. The first was one of the most important relationships in the school, and that is the relationship between the chair and the principal. And the concern is that the reason why the minister or her officials have suggested that the minister be able to appoint the chair is to take control of that relationship. And if that is not the case, then that's great. But if we could have an explanation as to why the chair, as opposed to a member of the Board of Trustees that has the capacity to vote like everybody else and can put there already, I would suggest that if the minister has made an appointee, they carry status. They carry status. They would have an effect on the conversations around the table. The other thing the chair is the voice to the media. So they actually then, when an incident happens inside the school, the general practice is that the principal is the day-to-day manager of the school and normally would be the first to comment to the media. But it is, Mr. Chair,
Tracy Martin.
But it is the Board of Trust, the chairman or the chairperson of the Board of Trustees' role to then be the face of the parental organisation that actually speaks to the media next. So why the chair is the question. Can I ask the minister also around, and we're now talking about it's clause 81 and it's a new section 98A, the minister may approve alternative constitution in certain cases. And this is around combining boards of state schools. There was one of the suggestions inside one of the regulatory impact statements on this particular clause was that when boards were combined by the minister, that the makeup of the boards would become too unwieldy, and that they suggested that the principal, who is a trustee by right, the staff trustee and student trustees for secondary schools be removed to actually make any combined board more workable. So can I ask the Minister around this capacity to create alternative constitutions? What does she see that means? Does, for 4 schools or 2 schools or whatever, has she taken on board those statements inside the regulatory impact statements that suggest that the staff, principal and student voice should be removed to make these combined boards more workable? Because that would be an extreme concern to New Zealand First. Thank you.
Chris Hipkins.
Thank you very much, Mr. Chairman. I wasn't
Remember,
quite.
can speak from anywhere.
I know. I wasn't quite anticipating that, but my notes are down here, so I'm very pleased to take a call on this particular section. Only a relatively brief contribution on this around the changing to the rules around school boards of trustees. I realised as I was preparing to speak on this that many of the points that I wanted to raise around statutory interventions regarding boards we'd actually grouped into the first theme, so I can't talk about them in this one. But I do just want to say I will ask for the House's indulgence just for a moment to say that I support the additional interventions. I think that they're a welcome thing because it does actually relate to Schedule 2, which sets out the power and functions of a school board of trustees and how they can operate. And one of the concerns that has been raised by boards in executing these functions is that if they ask for additional advice from the Ministry of Education, the default position has been to appoint a limited statutory manager, where many of them have been saying, actually, we could execute these functions much more appropriately if there was some gentler intervention available to the government and to the minister, and I welcome the changes to that. I've got some questions around the online, well, if you like, online meeting provisions and the ability for a board to effectively pass a resolution but not in a meeting. And clause 13 in the schedule under, what number is it? It's under number 40, meetings, in the schedule, says that a resolution signed or assented to in writing, whether sent by post, courier or electronic communication by all members, is as valid and effectual as if it had been passed at a meeting of the board correctly called and constituted. The question that I've got is whether unanimity is too high a threshold for that. School boards under this provision would need to convene a meeting to make a single decision if one member of the board dissented from that decision. And it seems to me that that's quite a high threshold, where if the decision is a relatively straightforward one and the board are trying to avoid the unnecessary expense and complication, bearing in mind that these are volunteers we're talking about, by passing a resolution by email, for example, and getting a written confirmation of the member's agreement. Why unanimity? Why not simply say, maybe the threshold for an absentee decision, a decision without a meeting, should be higher than at a meeting, but if the resolution could be passed by majority at a meeting, why would it need unanimity for that resolution to be passed using a non-meeting mechanism? Because it seems to me that what we're trying to do here is not unnecessarily require the volunteer parents who sit on school boards of trustees to attend meetings when there are non-controversial matters, say between meetings, that could be dealt with by simple resolution. And I've been part of committees where resolutions are agreed to via email and providing there's written confirmation that the majority of members agree. In fact, we do it in some select committee processes in this Parliament. And that's a very sensible thing to do. It means that we don't have to meet in order to agree a mere formality. So that's a question. Why the majority? The second point that I want to ask is around the combining and splitting of school boards of trustees and how these provisions relate to the provisions around communities of learning that we are going to further be debating. And some of the anxiety that's been raised by people within the educational community is that the communities of online learning provisions in this legislation, combined with the ability of the Minister to combine school boards of trustees, could lead by default to the community of learning becoming the default governance arrangement for schools in a particular area. That's an interesting debate to have, and I'm actually open to the debate. There's a whole lot of reasons why tomorrow's schools and that has led to a sort of a silo mentality when it comes to schools, and there's an interesting debate about how we break out of that, and communities of learning is part of the discussion, and this provision allowing the combining of boards is part of the discussion. What I'm interested in is where the government sees those two policies intersecting. Is it the government's desire to have the ability to create a single board of trustees for a community of learning? Because it seems to me that the two legislative instruments in this bill are being dealt with separately, and it's not always clear how they link. So I'd be interested in the Minister's comments on that.
Mr Chair?
The Honourable Hekia Parata.
Mr Chair, if I could just go back to a couple of points raised both by Ms Martin and Ms Delahunty in respect, in the first instance, of seclusion. The first is that the bill provides guidelines or provides for guidelines to be established already, so I don't think that an extra provision in that of that nature is necessary. Training is already in place. Workshops are available to schools on managing challenging behaviour. And it seems to me that schools should be in the position of saying this is something that we really do need to get to grips with because we have these challenges, and the ministry will respond. And where there are behaviour management plans, the ministry can provide specialist advice and will do so to those particular schools. In terms of the distinction between time-out and seclusion, because I agree with the members, it's really important, and it does depend on, body language as well as verbal communication, but also the context that's been established for kids. And to say that a teacher cannot make a kid go into time-out, whereas the seclusion we're getting rid of was involuntary, and there are already guidelines on how to use time-out, what alternatives there are to seclusion. Those were circulated to all schools last year when this issue became pressing. So both guidelines, general training and specific interventions are available. On the matter of the appointment of a trustee, thank you, I agree that there are times where that might be necessary. Again, I want to put this in the overall context that the bill is seeking to do, and that is to provide a continuum of interventions, because right now the threshold to intervene when a school is clearly in trouble is so high that the intervention actually is either a statutory manager taking over one, some or all, well, almost all functions, or putting a commissioner in and removing the board altogether. So the bill sets out a continuum that begins at a much lower level that says, look, we think there's a problem here, can we come, work with you, to the appointment of a new trustee onto the board. And the idea that that trustee might also be appointed as chair is still a much lower level intervention than a commissioner. And the chair, if a minister were to make that appointment, it would be circumstance specific, because that might be what is deemed to be required. But moreover, that chair would only have one vote, whereas a commissioner obviously becomes the board. So it's in the context of greater flexibility of interventions, it's in the context of what's fit for the circumstance of that school, and it's in the context of not going to some of the more stringent options to help a school recover. Coming to questions that have been asked most recently by Mr Hipkins, although there was also a reference by, I think, Ms Martin. Reduction of numbers would only occur where there were 4 schools or more that were combining, and there's no suggestion that that should be particular positions on the board, and all of it would be after community consultation. So it would be around, the point of governance, of course, is to be effective, not simply to have as wide a we do want to have wide representation, but it also has to be manageable. In terms of a question asked by Mr. Hipkins, there would be only two categories of reasons for combining boards: one where there were performance issues, or 2 where it was requested. And certainly it does admit of the possibility that over time communities of learning might say, actually, instead of having 10 boards, we'd like to have one more effective representative, one with good community participation, but it certainly doesn't prescribe that that should happen. And every question before a board must be decided by a majority, which is what you were concerned about, Ms. Martin. I think I've covered all the questions that have been asked, and if I haven't, I'd be grateful to have them repeated to me. Thank you, Mr. Chair.
Right, well, the ones that I think they've been covered, and therefore there being no cause, I will now move on to the next theme, which is the establishment of and types of schools, comprising clauses 98 to 116 and 144. Just say to members that this is one of the disadvantages of having a former minister in the chair, is that he does recognise a lot of it, and this is not that complicated, not that much change, and it's a bit of codification, so it's probably a bit of a well. Shouldn't take quite as long. Tracy Martin.
Very much, Mr. Chair. So, speaking to clauses 98 to 116 and clause 144 Integrated Act, which is specifically, actually, I want to talk about the changes to the absorption of the Integration Act, right? So I want to speak to my supplementary order paper 294, and what that tries to do is to put back in clause 144 into new section 442 as subsection 2. It's on page 81 after line 18, and it would read subsection to section 1: no prospective student may be refused enrolment at a state integrated school on the grounds of A, religion, race or socio-economic background, or B, lack of willingness of the parent to make financial contributions to the school. Now, we did ask at Select Committee why this was being removed. I think it was fuzzy, I'm sorry, but it was fuzzy from the officials as to why we needed, if everything else was being absorbed, why was this being removed? And if I can just go into the reasons how the removal of this clause can actually affect what's going on inside of state integrated schools once they're absorbed inside of the Education Act 1989 is, for example, where recently my officers were contacted by a student who was forbidden to go to chapel because their parent had not paid a particular bill. Now, the integrated schools are going to become, they're state schools. They're state integrated schools. There is a requirement no other state school can actually demand that things be paid for the delivery of the curriculum. If going to chapel is part of your timetable, if going to chapel is part of the everyday life of the school, then why would a school be able to stop that student from participating in that particular school-wide activity due to the inability or unwillingness of a parent to pay a fee? So the question is actually to the Minister, why has that been removed? And will she support Supplementary Order Paper 294 to reinstate it? There was another, well, actually, I'll probably leave it at that. If the Minister is able to answer that question, why has there been the removal of set clause 144? And if state integrated schools are going to be treated the same as every other state school when it comes to the capacity to provide free high-quality education, then why will they be allowed to refuse enrolment based on religion, race or socio-economic background? We recognise that there are protections for their special character in every other clause inside this absorption. Every student that goes there knows that if this is a Catholic school or a Hindi school, that is the special character, or Te Reo Māori Christian Catholic school, that is the special character of the school. But they should not be able to refuse enrolment based on religion, race or socio-economic background. So if the Minister could answer please, why was that clause removed in the first place?
Catherine Delahunty.
While the Minister's thinking about it, I'd just like to support the clause because the SOP by Tracy Martin, because and I'll make just a couple of very short points because I know that repetition is not welcome in this debate. But the reason that in the first theme, I raised the issue of including the rights of the child and various other UN conventions is because they protect us from discrimination, and this is a discriminatory clause. And it could be argued that private schools have the right to refuse children on this grounds. I don't know whether they do. But state integrated schools who receive state money in increasing amounts, and that's part of what we're dealing with integrated schools at the moment, should not have this power. And so I just want to make that point. And that's why we need some tests in the Act. We needed the conventions, and we also need to put this clause back in so that it's fair, because it's just blatantly unfair. It's potentially abuse of human rights, and you can't discriminate. Sorry, you would never, Mr. Chair. The government should never enshrine this kind of discrimination against the human rights of students because of race, economic status. These things are just unacceptable, and it doesn't do the integrated schools any favours that they came and asked for this to take place and that it's in the Act. It doesn't do them any favours. It actually makes us all look bad, and it shouldn't be allowed.
Tracy Martin and then the Minister.
Oh, thank you very much. Thank you. I'm sorry to interrupt the Minister, but there was another question. It was around section 106, 1B, section 107, 2B, and so on. It's the Minister's absolute discretion. So it's around, in the insertion of a clause, a decision to close a school under subsection 2 is in the Minister's absolute discretion. I just wonder if the Minister could, along with answering the question around why clause 144 was removed, I just wonder whether the Minister could speak to these absolute discretion clauses and whether they are an extension of the conversation that was had at Select Committee and through regulatory impact statements about removing the requirement of the Minister to consult again. Now, when I say again, if I can just outline, so when there's a suggestion that a school should close, let's take Redcliffe School, for example, due to an act of God, that's fine, but the Ministry had to go and consult around the options for that school. And they then came back to the Minister and they might make a recommendation that that school should close. At the moment, before this piece of legislation goes through, the Minister then, if the Minister makes a decision that the school will close, there is a requirement to go back to the community, now that the community knows that that is the actual decision made, not one of a line of options, the actual decision made, and for that Minister to reconsult with the community. And that's what happened at Redcliffe. Now, what I'm trying to get to is whether these clauses, 106 1B, 107 2B, Minister's absolute discretion, is taking away, reinforcing, and I think it might be somewhere else in the bill, that there is no longer the requirement of the Minister to say go back to communities like the Redcliffe School community. That once the Ministry has outlined all the options, and then they go away and tell the Minister what they think the Minister should do. Minister makes a decision, that's it. Now, so if the Minister could please address those two questions, I'll be most grateful.
Oh, Mr. Chair, I'll just answer the questions that have been asked in the last wee while. So the first thing is, in respect of Clause 144, the answer to that is that the Human Rights Act covers far more than this clause, and that's why the bill has referred to the Human Rights Act instead of a definition that is much narrower in this bill. So that's the first thing. The second is that schools can't refuse enrolment based on religion because the Human Rights Act protects that. The third question is in terms of consultation. Does absolute discretion remove consultation? No. Thank you, Mr. Chair.
Sue Moroney.
Thank you, Mr. Chair.